So today we are going to discuss about some important provisions under the Indian Patents Act which relate to the secrecy directions and also the need to acquire a foreign filing license. So these provisions relate to specific type of patent applications as we'll discuss in this lecture. So as you are all aware that patent applications are brought to the public notice by way of publication. However, there are specific subject matters which require special scrutiny by the government of India because such subject matters may relate to the security of India, and thus these provisions have been included in the Patents Act, wherein specific permission of the government needs to be taken before the application could be published or may be processed. So here we'll be discussing about section 35 and section 39 of the Patents Act. So coming first to the provision related to secrecy directions, which is provided under section 35 of the Indian Patents Act. This provision specifically pertains to inventions which relate to defense related subject matters which may have been notified by the central government or any other subject matter which the controller feels may be important in respect of the defense of India. So in case the controller feels that any of the patent application relates to such subject matter, then he could direct for prohibition of publication of that particular invention, and thus it does not come into the public disclosure. So you are already aware that for any patent applicant, publication of his invention or patent application is an important step that consolidates his rights. But in specific relation to section 35, it curtails the rights of a patent holder or a patent applicant. His invention, if it relates to a specific type of subject matter, it won't be published unless and until there is a clearance given by the central government, as we'll see in the next few provisions. So what happens after the controller gives the prohibition order? He forwards the patent application and the contents thereof to the central government so as to enable the central government to review the subject matter. In case the central government feels that the invention is not prejudicial to the Indian security, then the central government may ask the controller to revoke the instructions that have been given for prohibition of publication. So there's another way in which a secrecy direction could be given, and that is directly by the central government, which is provided under section 35 subsection 3. So in case a patent application has escaped the scrutiny of the controller and the central government becomes aware of a patent application which has a subject matter which may be relevant to the defense of India, then the central government may ask for a review of that particular patent application, and if the subject matter of that particular patent application is found to be relevant for defense related purposes of India, then it may notify the controller to issue a secrecy direction under section 35, and this action could happen anytime until grant of a patent. Thus, there are two ways in which a secrecy direction could be given, one by the controller under section 35(1) and another one by central government under section 35(3). Also, the secrecy directions are not permanent in nature, and thus those could be revoked at any time upon instructions of the central government. We'll see this in the upcoming slides. For easier understanding, I am sharing a sample notice which is sent by the controller of patents to the government of India under section 35(2). So you can see here the controller is informing the central government about a particular patent application. They have forwarded the patent application to them and also requested them to consider whether the subject matter is relevant for the purposes of issuance of secrecy directions. So let us see what are the consequences of issuance of secrecy directions, and these consequences are provided under section 37. So one of the consequences is that there could be no order of refusal to grant until the secrecy directions are in force. So your patent is safe from refusal until the secrecy directions are in force. Now what could be the reason for this particular provision? Maybe because then order of refusal, you need to have a detailed reasoned order, and that detailed reasoned order has to come in the public domain. So probably since the secrecy directions are in force, you cannot in a way disclose the contents of that particular application even in an order of refusal, and thus that could be the reason behind not providing for any order for refusal until the secrecy directions are in force. Again, the provisions provide that there could be no appeal against any order of the controller in respect of a patent application which is under secrecy directions. Again, this might be curtail the public disclosure. Another provision is that in case the patent application is found to be in order for grant, it may proceed up to the stage of grant so that no patent would be granted and no publication would happen, but it would reach the stage of being in order for grant. So what that means is you could have an FER issued, you could file a response, you could have a hearing and even a discussion with the controller so as to put the application in order for grant, but all the processes would stop at that particular stage and no further action would be taken unless and until the secrecy directions are revoked. Further, in case your patent application has been found to be in order for grant but the secrecy directions are still in force, then in case the central government is using your invention or someone on behalf of the government is using your invention, then all those such acts or use would fall within the purview of section 100, 101 and 103. Additionally, in case the central government feels that due to the secrecy directions the patent applicant is facing some hardships, then the central government may decide a compensation that needs to be paid to the patent applicant when the central government is using that particular innovation for its own purposes. The provision provides that the compensation could be decided based on the aspect of novelty and the utility of the invention and the purpose for which it has been provided. Section 37 also provides that no renewal fee is due for the period during which the secrecy directions are in force. So once the patent is granted, you need to pay annuity fee counted from the third year onwards. If the secrecy directions are in force, so the patent applicant would not be required to pay the renewal fee for the period for which the secrecy directions are in force, starting from the third year onwards. So if you remember, I had talked about the secrecy directions not being permanent in nature. So here we'll discuss how the secrecy directions are revoked by the central government when it is no longer relevant. So section 36 provides that the secrecy directions are to be periodically reviewed by the central government at an interval of 6 months or whenever there is a request by the applicant. So the applicant could also make a request in a period lesser than 6-month interval. The factors that may be considered by the central government while revoking the secrecy directions would be that the publication of the invention would no longer be prejudicial to defense of India. So whatever is the subject matter, if it is brought to the public domain, it would no longer be prejudicial to defense of India and thus it could be safely published and thus the secrecy directions could be revoked. The other thing that could happen is that maybe the patent application is one of the corresponding applications of another foreign application that has been filed outside India and that has already been published outside India. So now it is already in the public domain. So the government does not need to prohibit the publication of that particular innovation in India also. So based on these considerations, the central government may instruct the controller to revoke the secrecy direction. Further, to protect the rights of the patent applicant, which may have been hampered because of the secrecy direction, section 38 provides that the controller may extend time limit for doing any act which is connected with the patent application, but he may specify certain conditions based on which that time could be extended. Rule 72 sub rule 2 provides that the extension period should not exceed the duration for which the secrecy directions were enforced in relation to the patent application. So this is all about the secrecy direction provision under the Indian Patents Act. Next, we move on to the provision related to foreign filing permit, which is provided under section 39 of the Patents Act. So what it basically provides is that Indian residents cannot file a foreign patent application which is outside India for any invention unless they have already filed an Indian patent application for that particular invention in India first and 6 weeks from filing of that particular Indian application have lapsed. So if you are an Indian resident and you have conceived an invention, then you cannot file a patent application for that particular innovation outside India unless you have first filed an Indian application. Then after 6 weeks of filing of that particular Indian application, you can go ahead and file a foreign patent application outside India. So the logic behind that is, if you have made an invention in India and you have filed a first patent application in India, then the controller would be able to see the subject matter, whether it relates to something which is related to the defense of India, and then control the publication of that particular patent application. An alternate path that is available is that if the patent applicant or the Indian resident who wants to file a patent application outside India needs to seek a foreign filing permit from the controller of patents before going ahead with filing of the foreign patent application. So you need to submit an application to the controller of patents seeking his permission to file the patent application outside India. So section 39 subsection 2, when read with rule 71 sub rule 2, provides that any application that has been filed to seek foreign filing permit needs to be disposed within 21 days of filing of the application. So what happens is the controller goes through the subject matter for which the permission is being sought, and in case it relates to defense or atomic energy, then the permission of the government is sought before giving up any permission to file the application outside India. Also, the 21 days are to be counted from the date of receipt of the permission. In case the subject matter relates to defense or atomic energy and a permission has been sought sought. So 21 days would be counted from the date on which the permission has been received from the Government of India. In case the subject matter doesn't relate to defense or atomic energy, then the permission would be given within 21 days of filing of the application seeking foreign filing permit. Moving next to the procedural aspect of a foreign filing permit, Rule 71 Sub-Rule 1 provides that the application seeking foreign filing permit is to be made on Form 25 along with the relevant fee. So along with Form 25, you also submit details of your innovation. So maybe a brief summary of your innovation so as to enable the controller to ascertain what is the subject matter of the invention. This application could be filed by the Indian resident who has made the innovation or an assignee who is in possession of the innovation, and this application would then be made on behalf of the resident individual. So in that sense, you'll have to show how the assignee is in possession of the invention if there is some assignment from the resident individual to the assignee. So please note that this permission is only to be sought in respect of innovations that have been developed or conceived by resident of India and not the citizens of India. So there is a difference between resident and citizens. The Patents Act does not specify what is the definition of resident, and thus for that specific purpose we could refer to Section 6 of the Income Tax Act, which provides that a resident individual would be one who has been in India for 182 days or more in the previous financial year. So for example, if you want to consider if a person A is a resident of India, so you are considering this question in the present financial year. So what you have to see is whether he has been in India for 182 days or more in the previous financial year. Or there is another condition, he could be in India for at least 60 days in the previous year and an aggregate of at least 365 days in the 4 years preceding the previous financial year. So this is all provided under Section 6 of the Income Tax Act. I won't go into the details of how to interpret that is separate topic altogether, but we could gather the information regarding who would be considered as a resident in respect of this particular provision under Section 39, and we could rely on the Income Tax Act for that particular purpose. Similarly, if the innovation relates to a resident company, then it could mean an Indian company or a company which has an effective management in India. So all such residents need to apply for a foreign filing permit before filing any innovation outside India in a foreign patent application. So in the beginning I had mentioned that Section 35 and Section 39 are very important provisions, and any contravention of these provisions could relate to some severe penalties being imposed on the patent applicant. So Section 118 provides that any contravention of these two provisions may result in imprisonment of up to 2 years or a fine or both. Also, Section 40 provides that a patent application would be deemed to be abandoned, or a patent, if any granted, could be revoked under Section 64 in case there is found to be a contravention of Section 35 and Section 39 or either of those by the patent applicant or the patentee. Thus, both these provisions are very important, and the patent applicant needs to take care that these two are complied with, and necessary permission as is required may be sought from the government in case you are intending to file a patent application outside India before filing it in India. So this is all about Section 35 and Section 39. In case you have any questions, please drop them in the comments box and I'll be happy to answer those. Thank you very much.